Now we're going to start our fourth session of the day. It's going to be me, Chris, and Sahara will be giving this last session. And so we'll be talking about practical tips for updating your data processing addendum. And so, again, we're going to really focus on the practical here is going to be the emphasis. You're going to get specific provisions that you can add to your data processing addendum. I'm going to start calling it a DPA. You'll hear that. Sometimes it's also referred to as a data processing agreement, but you will get the whole thing. And also I should mention, we will send out these slides. We got a few questions. We send out the slides. Definitely, we will be sending out the slides afterwards. Also, we will, I know CLE was promised. We're still waiting for final confirmation, but we will get it and we'll send that out afterwards as well. Okay. So what we'll be talking about is the specific requirements to your DPA. There's some specific additional requirements in California, and then some international data transfer additional requirements for your DPA if you're processing data internationally. Now that at that point we'll be actually leaving. We will stop talking about California and Colorado. We will like go abroad and talk about the EU, and it'll be very interesting because you'll be like, I'm so sick of hearing BCDPA in my lexicon. So we will do that at the very end here, some updates that are a lot of our clients are facing. And so I'm going to give you the probably most busy slide that you will see today. So in this, while you digest this, let me say why, if you're not generally a DPA, a data processing addendum, came into the legal lexicon back in 2016 when the GDPR came into effect. We had there was a requirement under Article 28 that you include certain things in your contracts between controllers and processors. And so this really started, and now it has, if you practice in this area, I'm getting some head nods, this has beguiled you for the last 6 years, and you are very familiar with what are the requirements under the GDPR. Start in 2018, and then once it became effective in 2020 with the CCPA, there were some minimal requirements, but now we're going into hyperdrive. We're going basically full GDPR land with our DPA requirements, as you can see here for the various states. And you may be thinking, why do I need to do this? Like, this is ridiculous. Like, this is a lot. If you're not familiar with GDPR, I get that response a lot. But this is a focus area. And as we pointed out earlier with the Sephora enforcement decision, one of the 4 key things that they said is that Sephora had to conform its vendor agreements to the CCPA's requirements for service providers. It is clearly an enforcement area. Why else do you need to do it? In the CCPA regs that are still in draft, they say, and this was new language, again, still in draft, but it says, where a business conducts due diligence of its service providers and contractors factors into whether the business has reason to believe that the service provider or contractor is using personal information in violation of the CCPA. So you have to do due diligence. What does that mean? They say, for example, depending on the circumstances, the business that never enforces the terms of its contract nor exercises its right to audit or test the service provider's systems might not be able to rely on a defense that it did not have reason to believe that the service provider was not in compliance. So that means if you're not putting in place a DPA, they're going to say you're not doing your proper due diligence. Let's say you use Google Analytics or you use Facebook Connect or something that has been found to be maybe a little dicey from the regulator standpoint. They say if you're not enforcing this, you could be liable for their obligations. What I just read also says further that if you're not auditing and testing their systems, what ability do we have to do that? Then you may not be able to use that defense. And so you still might be liable for the processor's obligations. It's really, basically, the point is, this is very important. From the regulator standpoint, this is an area of enforcement, and it will be required in your contracts. And so going back to this slide, hopefully I have time to digest it. Basically, what I would take from this is there are all these GDPR requirements. You likely, if you're familiar with them, you likely already have these contracts in place. Once we get into 2023, all those requirements, basically the net of these state requirements, basically all come into your contracts for your US data transfers, your US service providers. whether you are the service provider or the controller. So the processor or the controller. And so you have these in, I will say, with the exception of subcontractor liability, which just means you have to be responsible for, you're liable for your subcontractor's actions and international data transfer. That is, in the US, we do not have restrictions on international data transfer. We'll talk about those at the end of this presentation with regard to transferring data from the EU and what is required, but not in the US, still not in the US. So let's go through each one of these. And again, this should be practical. You're going to get specific provisions. You're going to get specific things that we need to add to our contracts. So first, you have to comply with applicable laws. It seems so basic, and it's a basic statement here, but that has to be stated. It's not just that you are in compliance with applicable laws, it's that you've required your service providers to be in compliance with applicable laws by contract. They have to make that representation. They have to be compliant, and specifically here, with, because it's only Colorado, only California, with the CCPA, they have to say by representation, written representation, that they are in compliance with applicable with the CCPA in this instance. And I should mention, all these example provisions are from a processor-friendly standpoint. Just there was already too much text on here, so I only put the processor-friendly. I would say this is if you are a service provider or a processor, this is about what you would want to put into your DPA. The scope of processing. So this is a new requirement, and this causes quite a bit of additional language in your DPA, because what it says is with specificity, you have to describe what is being processed. So what is the subject matter information of that processing? What is the nature and purpose? All the categories of data subjects. Right now, the requirement is that you have to specifically identify these things. In practice, best practice is generally you include an exhibit with these headers, and you point to the contractual documents that may have details to this effect. Like you may point to an SOW in an order form that might describe what data you are processing and for what duration. Maybe you have the term of the document stated in the order form. So largely, it does cause a lot of, you might largely see this in the data processing exhibit. You're going to see a lot of, I'll point out where we can move things to exhibits of the DPA, but this is going to be a new requirement. Document instructions, this here, basically that we will adhere to the instructions of the controller. What does that mean? Written instructions generally, but how far does that go? Is it written instructions of the contract by email? They have to put a specific notice in here. You want to kind of you want to confirm this or kind of confine this to your expectations of what could be an instruction. I put a sample in here for you. Confidentiality, that you have to treat the personal data as confidential. Basically, you have to treat it confidentially. I want to say this is different. The requirement is not that the data is confidential information. And I would say if you're on the processor side, this is kind of a practice tip. If you're on the negotiating on behalf of the processor side, largely you don't want to say the personal data that the processor receives is the confidential information of the business, because what you will find in most of your agreements is that confidential information has certain protections in the agreement, largely maybe carved out of the limitation of liability. There may be an indemnity related to disclosures of confidential information or not processing confidential information appropriately. So I do want to make this very clear. There is not a requirement that has to, the personal data that the processor is processing is actually confidential information. It just has to be treated with confidential terms, basically. And you can see the distinction here by reading the example. Security. So this again it's an interesting one because you have to layer, there's about 25 to 30 states right now that have data security requirements that, so those are outside of the laws that we've been talking about. These laws bring those, they have to be part of this contract. So largely what you will see is some type of general representation that you use reasonable and appropriate or reasonable administrative, technical, might be organizational and physical measures, generally to protect data, protect the confidentiality integrity and availability. Sometimes you hear that. These are kind of like general standards, like talking about reasonableness. Those are general standards. But here we have to do it generally what you find with specificity. So there will be minimum standards. And those are generally stated in a security exhibit. Though I should say there's not specific standards right now under these laws. Like you don't have to have multi-factor authentication. You don't have to have certain levels of encryption under these laws. You have to layer this, like I mentioned, with certain sectorial laws, sometimes like financial information or other like health data, PHI, there are specific requirements, not under these laws. Those specific requirements are dependent on the data that you have, the industry that you may be working in. Those would go into the exhibit that you have here. Subcontractor authorization. This is new, this is a familiar GDPR land. And so here we have to get authorization. So what does that mean? And then you have to also flow down your terms to your sub-processors. So for our SaaS clients that have their own SaaS product, they're a processor of the data, they may use a number of other sub-processors, hosting providers. Maybe they might use Zendesk for responding to customer tickets. All the different service providers that you use, you have to flow down the obligations contained in the DPA down to the service provider. So first you have to get authorization. The best practice right now is to get what's called general authorization. And that's what's specifically required under US laws. If you're familiar with the GDPR, and I harken back to that because a lot of our clients already have DPAs in place under the GDPR, it's either specific or general authorization. US only is general authorization. What does that mean? It means that you provide a list of service providers up front, and then those are approved, and then you identify modifications to that list. So as opposed to for each individual service provider on the initial list that they have to specifically authorize those individuals. Hopefully that is it's a fine distinction, but general authorization is the standard in the US. Generally what we see is some type of at least 10-day advance notice, a 10-day objection period. This is where it gets a little bit dicey and I get a lot of variation, but some type of, if they do not consent to that sub-processor, there's usually some type of limited termination rights or some type of recourse rights. They might be able to terminate specific to what that service provider is doing. So if it's just customer tickets or it's just a certain product, certain feature of your product that you're using that service provider for, they may just be able to terminate that aspect or that SOW. But there's usually some amount of recourse rights here if they do not approve a service provider. In practice, it rarely happens that a service provider is not approved. Because most people are not in the business of, like we understand a lot of SaaS clients, they're one-to-many, they're providing service providers for all of their different clients. It'd be very heavy-handed for one business to say, no, absolutely, you can't use this provider. Generally, you're not talking about competitors here, so it's usually not a problem. Flow down obligations we talked, you have to pass down the obligations. Now, interesting here is a no less protective standard, not the exact same obligations in the DPA. It's a no less protective standard, which is a little bit softer than what you'll see in the GDPR, which is the exact same protections. So responding to data subjects. So this is an obligation to help the controller respond under their obligations. So specifically, and I see a lot of confusion on this point, it is not a requirement for a processor to respond directly back to the data subject in accordance with what we have just talked about in our session 3. You don't have to, you do respond and you can direct them to the controller, but it's not, you will find all the data and delete it and provide access to it directly to the consumer. If you're the processor, and all these, I hope I made it clear that these obligations are obligations on the processor. And so that's why we've kind of defined these examples for how you would respond in the example provisions. But the processor's obligation is to just notify the controller. And generally that is followed up. That's the legal obligation. The contractual obligation could be more. It could be you have to do certain things to assist the controller. You have to do, various measures. You have to respond in a certain amount of time. But there will be an obligation that the processor notifies the controller, so upstream. And I mention that because, if you were to respond directly as the processor directly at that subject, you may be in breach of your contract. So you also, in addition to helping the controller, you assist them with responding under their obligations to data subjects. You are consumers. You also have to help the controller with regard to their own security. So how can you help them? What are measures you can take? You can put in place security guarantees. You can have certain assessment rights or monitoring rights. You can provide records of your processing, security documentation, and I mentioned audit. So basically providing certain insights into the processing activities that the controller can then use so that it can make its own representations with regard to its vendor management program. You can assist those ways. It's not here, I want to make this clear, it's not here for so controllers can outsource their security. That's not what the law wants you to do. The law doesn't want you to say, controllers, just pass all your legal obligations down to your processors. There was a time when a lot of controllers want to do that. That's not what, it won't give them a life raft, won't give controllers a life raft, and nor do processors have to take that on. But processors have to give some insights into their own security obligations that assist the controller with regard to their vendor management obligations. Also assisting in a data breach. Now, all the time I see, not only do you have to notify me, but you have to notify me in a certain time frame. You have to do all these things, and you have to pay for all my costs. You have to do all those things. No, you can see the requirement here. It's much less. It's assisting the controller with regard to their own obligations to respond to individuals within certain time frames, maybe to provide credit monitoring if it's required. Those things are on the controller. So the processor here, you can see, are very limited obligations. This is the full, from this Virginia's law, but this is the full requirement. There's no time frames in here. There's no, you have to take on their costs. Despite that, and we get this a lot, almost in every DPA negotiation, there are certain best practices. Inserting a notice generally within the time frame that you can meet. Largely, it depends on what laws the controller is subject to. Are there strict laws that, like the GDPR, where they have certain time frames, or is it more of a general standard like you see in some state laws? There's also specific requirements under some state laws. But you look at what is the controller subject to, and then what time frame we can provide that notice in. Some reasonable assistance such that they can meet their own obligations. Doesn't mean that, reasonable assistance doesn't mean that you have to allow them to send their own investigator on your site to do their own forensic investigation, and you have to set up, stop your business and set up all these interviews. We get that request a lot. That's not what the requirement is. So you may have to do that because you're negotiating in a very powerful, entity, and they might be able to force some of these obligations on. But it's important to know the strict requirement. What you have to do and what you don't have to do under the law. And then you'll also see some amount of reasonable records with regard to your own investigation, and usually, this is best practice, not law, some amount of cost recovery. We get this. This is such an important point that gets negotiated in so many DPAs. So what amount of cost recovery generally are you looking at, and what is best practice? In my experience, it usually comes tying into what are the controller's obligations under the law, under breach notification laws. Generally, they have obligations to notify individuals. They may have to notify certain regulators. So notification costs could be subject to some type of cost shifting. And you may say, if you're representing a processor or a service provider, you may say, if I have a data breach, yeah, I don't want to leave my controller, my customer high and dry. That might be reasonable. Costs of notifications may seem reasonable. And so not required by the law, I want to be very clear, but we generally see that there's some limited cost recovery. We also see some cost recovery from sometimes credit monitoring is appropriate and sometimes required under certain laws. So you see that. What you don't see, and I always push back on, is allowing them to, how many forensic investigators they want to hire, how many attorneys they want to hire. They could hire all different types of New York attorneys that do or do not have any knowledge of data breach response. You know, any number of forensic investigators and communications specialists and all different types of things not required by the law. We're not going to gold plate their system upgrades and system improvements on the controller side. Those things are outside our control. And so those are not appropriate, generally is my argument. Again, not required by the law, and I believe not appropriate if the processor can't control the spend, and it's not required by law. Generally, that usually wins the day on the processor side. Assist with data protection assessments. Again, this is an obligation on the controller, but providing reasonable assistance from the processor side with regard to the controller's obligations. Delete and return the data. This is so once the processing is done, this is specific to personal data, but there is an obligation that you delete the data unless there's another legal requirement. So all of these laws have general exceptions with regard to compliance with other applicable laws. There are certain data types and there are laws related to those data types that have retention requirements. Sometimes employee data, depending if the company's public, there might be additional requirements under Sarbanes-Oxley, but except as required by applicable law, the general obligation is once the service is complete, you will delete or return the personal data. Again, records, inspections, audits. This is a hard one for a lot of our processor clients because they're not used to accepting audits. Now, I want to be very clear. This does not say that there can't be some cost shifting if you're a processor that has to undergo an audit. There is no statement that you could not recover some of your costs. If maybe that audit goes above a certain amount, maybe 10 hours, you could recover your time and materials costs. That's not explicitly barred. You could do that. You know, may not work for the controller, but it's something you can try. I want to make sure that it's clear. You, as a processor, you have to submit to it. It does not say that you have to pay for it. Any amount of auditors, especially, again, these are largely outside the control of the processor. It's usually someone hired by the controller. There's a term for it, the mandated auditor under the GDPR. Those are required obligations, but you do not have to pay for it as a processor.
All right, we are back to our favorite state, California. Thank you, Chris, for talking through all the general requirements that are applicable to all the states. There are some additional requirements, of course, for California, and I'm going to talk through those with you. So for starters, here's some background information for those that have been with us the whole day. We've talked about the California laws. For those that are just joining us for this session, the laws that the provisions that I'm going to talk about come from three sources. That's the original California Consumer Protection Act, its amendment, the California Consumer Privacy Rights Act, and then the implementing regulations that are being promulgated by the California Privacy Protection Agency. Those regulations are still pending, but we have included them in today because of how far along they are. So before we get into the specific provisions, I just want to talk about some of the definitions that are specific to California. And I want to start with contractor and service provider. A contractor is a person to whom the business makes available a customer's personal information for a business purpose pursuant to a written contract with the business. A service provider is a person that processes personal information on behalf of a business and that receives from or on behalf of the business consumer personal information for a business purpose pursuant to a written contract. If you're listening to those two and thinking, she just read the same thing, the technical difference is very small and the practical difference is non-existent. So in reality, we treat our service providers and our contractors as one, as vendors or subcontractors, processors or sub-processors, any of those words which are consistent with the other state laws that we've talked about today and with the other concepts of privacy that we've talked about. Those are our vendors. And California adds another definition, and that's of a third party. And that third party is defined as an entity that isn't the business or that isn't the service provider or the contractor. And we're going to talk about how California adds requirements on to the service provider. Third parties may include internet service providers or browser providers or advertising partners, so that you can have an idea of who they're referring to when they're talking about third parties. The next set of definitions, business purpose versus commercial purpose. Business purpose, I tend to think of as an operational purpose. You have the service that you're providing to your customer, and then you have all these ancillary things you need to do as a business to be able to provide that service. Some examples are audits, security for your network, and continuing to develop your product and technology. Commercial purposes are commercial transactions in the economic interest of the organization. And then we have finally the sale versus sharing. A sale is the transfer of personal data for monetary or valuable consideration. Sharing does not have the requirement of the exchange of value or monetary consideration. It is, however, related to the cross-context behavioral advertising, which we generally refer to as tracking or behavioral advertising. Both terms are affiliated only with the term third party. So if you read through the statute, you'll see a third party when you're talking about transfer of personal data. When you're talking about a third party, the personal data will have been sold or shared to the third party as opposed to disclosed to your service provider, contractor, or vendor. So I've got a chart similar to the one that Chris developed to show these additional provisions, 9 provisions, and how their applicability to service providers, contractors, and third parties. And we're going to go through those provisions. The first 5 are directly from the statute and are applicable to third parties. Chris started.
Before we go into the next slide, I just want to point out, like, this is a bit this is big on the DPA landscape. And the reason it's big is because you have obligated, first, it's big in that these are additional to the GDPR. So this means that, let's say you're relying on your GDPR DPA to cover all these obligations. These aren't covered, as we mentioned. So I want to be very clear. We stated in the beginning, all those were GDPR requirements that have analogs in the US. These are additional requirements that have to be added to your DPA. So you cannot just rely on your GDPR DPA. Even if all these yeses had equal weight, you do need an update to your DPAs once California is implicated. 2, the reason this also is big is there's specific things that have to be in your contracts for third parties. So right now, what you would have, I mean, you basically are talking about controller to controller transfers. So again, third parties are not the business, the original business that's the controller in the first sense for scoping, or it's not the service provider contractor. Those obligations do flow down on those, as you can see here, but they also flow down on third parties. So there are specific the specific contractual obligations that have to be in your contracts between controllers and controllers. These very well could be contract obligations if you're sourcing data in, you're getting data from a data broker potentially, or some type of enriched list. You have to have obligations from that controller who decided to sell it to you, and then you decide how to use it. Both parties are businesses. There are now required obligations. Most people miss these because even in the GDPR context, there's no specific requirements in a DPA between controller-controller transfers. There's a general obligation under Article 26 that two controllers that are transferring data have to have some contractual document, but there's nothing like Article 28 that has these specific requirements. So these are new and in addition to what we're seeing in the GDPR, and require like just a ton of updates where there was none before.
So the first of these requirements is the limited and specific purpose. And you heard Chris talk about this as it relates to the vendors or the service providers and contractors. And as Chris just stated, this is new because it is now being applied to third parties, to those also controllers. Likewise, we have the requirement to comply with the CCPA. Another requirement that for general, all the state law, the state privacy laws that are coming out, that requirement is there for vendors. Here, it is also required for third parties, and you have to include that in your data protection agreement. The right to monitor is another requirement that is on both the vendors and the third parties. And I'll read from the statute to understand that language. The business is granted right to take reasonable and appropriate steps to help ensure that the third party, service provider, or contractor uses the personal information transferred in a manner consistent with the business's obligations under the title. So this is giving the business inside of a DPA as a requirement of the statute to monitor these vendors and these third parties to make sure that they're doing what they should be doing. And the opposite side of that is the requirement then on the service providers or vendors and on the third parties to give notification to the business when they can't comply with the obligations of the statute. And all of those two components together give the business this opportunity to remediate. So we see often the opportunity to audit that Chris talked about in the general section. And now in addition to just auditing your vendors, in addition to auditing now these third parties, you have the business has the right to do something about it when they aren't complying. And they can do something, what is typically you would see is that the business might stop sharing personal data until there was a change in the actions that are causing the non-compliant use of the personal information. These next three provisions are not applicable to third parties. These are focused on our vendors, our service providers, and our contractors. And these are found inside of the statute under the definitions of service provider and contractor. And here specifically, and we've talked about this selling and sharing a lot today, but here we see it again. There is a prohibition on your vendors, processors, selling and sharing data. And that's consistent with what I shared in the beginning with the definition, that third parties are the entity that sharing and selling, selling for monetary gain, sharing for tracking purposes are related to, and vendors should not be participating in that action. And likewise, vendors also cannot receive the personal data from the controller, from the business, and then combine that with personal data that vendor is collecting from other sources, perhaps other customers that they have, because as Chris stated, a processor may have multiple customers. You cannot take personal data from two different customers and combine that information, or combine it with information that you are collecting separately. This next requirement is really the only material difference between the contractor and the service provider under the CCPA. And that is that a contractor is required to include this certification inside of the DPA that the contractor both understands and will comply with the law. But again, because it's very difficult to determine whether a processor is a service provider or a contractor, that line is, essentially non-existent. These requirements should be applied to service providers and contractors. And then we have finally a data subject request communication. And this is really what Chris referred to earlier, the processor's obligation to assist the controller with data subject requests. Here we have the statute. This comes from the regulations that are pending, talking about, well, what happens when the data subject request really is directed to information that the third party or the vendor has. And what the statute is saying, what the regulations are saying is, in that case, then the controller then has an obligation to both inform their vendors and provide any necessary information to their vendor to ensure that that consumer can exercise their right to receive that information from the vendor. Likewise, because the third parties are not processors, they're on the controller side, and that the personal data that they collect is that third parties to own. Through this DPA, the business is now requiring the third party to respond to data subject requests. Again, the goal here is to ensure that consumers are able to exercise their rights. And we provided a sample provision for you on the next two slides. I won't read through those provisions, but you can see there's some sample language that you can use. And then here, just really reiterating what Chris said earlier, is that these provisions are meant to reduce the risk of businesses and ensure the rights of consumers are realized. It is beneficial for a business to execute a DPA so that they can protect against risk and use their rights to be able to use the defense against any liability if there is an allegation that they have breached the statute, or even if there's a data breach. I'll read off our last distance learning CLE. That's primarily for Indiana. We have CLEs pending in Indiana and Colorado. And if you're distance learning from Indiana, the code for this session is data protection, and you can email me that code at swilliams@kofirm.com.
Thank you, Sarah. It's really great. So that's, now we're gonna, finally, we are leaving the States. We are going internationally. We are gonna do an, also what you are probably seeing is they haven't talked about certain international data transfer requirements that I see in my DPAs all the time, and they make up a substantial part of your DPA. And so we're gonna cover them here. But no, we are now leaving the States. These are current requirements that need to be in your DPA. And so these are already in effect. You see here where we are. This is going to harken back to our that lovable little scamp, Max Schrems, and we all love him. And he, you may know, he has filed some cases, and he's been quite successful with the European Court of Justice. And in his last, most recent attempt, or he was very successful in what's called the Schrems II decision. And essentially what that decision said is that you can no longer use the privacy shield that is a compact between Europe and the Department of Commerce, the European Commission and the Department of Commerce, so that data can be transferred from the EU to the US, not specific to other countries, obviously, it's just the Department of Commerce, the US Department of Commerce. And so here now with that, a lot of companies that were relying on Privacy Shield for their transfer said, well, what do we do? Well, European Court of Justice has an answer. You can continue to use the standard contractual clauses with certain additional measures, without really going into what those measures are. They kind of harken to some reports, but don't really go into it. So, okay, sounds good. A lot of companies were using standard contractual clauses, so that sounds great. And so then, about a year later, in the EU, the European Data Protection Board publishes new standard contractual clauses, which is actually good. And we'll talk about some of the benefits of these new standard contractual clauses, but they are detailed and they are needed, but they are detailed. And so we'll dive into those a little bit. Then the European Data Protection Board also gets supplemental transfer tools guidance. Talk a little bit about that. You start seeing other non-EEA countries, so with Switzerland, and then post-Brexit, the UK published their own transfer mechanisms. In Switzerland, they have an addendum such that you can use the 2021 standard contractual clauses. The UK says you can use an addendum, or you can use our own international data transfer agreement. Okay, we're past all that. We need these in DPAs. You've seen them in DPAs. We'll talk about how you can implement them in your DPAs if you're not already doing so. There are some transition periods on when you need to do that, and I've highlighted them here, but we are well into this timeline. This is not forward-looking, this is backward-looking, and this is, if you don't have this in your these in your DPAs and you are transferring or receiving data from Europe to the US or anywhere outside of Europe or the UK, you do need these mechanisms in place. So why did we need new ones? Because the old ones were incomplete. They only had certain coverage. You only had a controller to controller transfer. So where you were exporting from a controller in the EEA, these are old, as you can see here. There's 2001 and 2004 to a non-EEA country. Now you have the same requirements in the UK. You're likely familiar. But basically we had these old controller to controller sets. There's very little distinction between set 1 and set 2. Essentially, they're now sunsetted, so I won't go into the distinction, but you also had a controller to processor. This was heavily used. And this, again, but from 2010, I mean, we're 20 years past these early standard contractual clauses. We definitely needed an update. I mean, the GDPR happened since all of these. So what did we get in 2021? We get coverage for all these processing scenarios. Controller to controller, all the way around. And so we now have modules for all of these different processing scenarios. Now, what happened, and because the GDPR is more detailed than these standard contractual clauses, there needed to be an update for full coverage. And so there are now additional requirements in these standard contractual clauses. You have to be more detailed in your description of processing, in your description of your security measures. There's additional obligations on your service or your sub-processors. The big one, and this is, you find this in clause 14 of the standard contractual clauses, is there has to be some representations with regard to the laws and practices of the importing country. Why is that big? Because the whole idea that Europe is worried, and Schrems too, and in various other guidance, is they're worried the US government is like coming in and swooping up and getting all that good European data, consumer data, and they want to, use it all, and they're using backdoors. And so basically, Europeans are worried that the US government or other governments around the country are surveilling European consumers. And maybe there's some truth to that, that they got different political opinions, but for whatever the case may be, in these standard contractual clauses, there's now additional requirements that the importer and the exporter work together and make certain representations of what are the laws of the land, and are they sufficient to provide adequate security to the exporter that the data will be safe. And two, if the importer was to receive a request from a regulatory agency, what would the importer do? Would they notify the exporter? How much time? Will they try to fight the request? What are those things that they would do? And there's certain guarantees that you find in these standard contractual clauses. And also, yeah, again, providing assistance, we covered that. So now the other interesting aspect of these standard contractual clauses is there's selections you can make. Now in the old standard contractual clauses, there's largely no selections. They're standard, right? You have to keep the terms. They wouldn't be standard contractual clauses if you could modify all the terms. It wouldn't be standard any longer. Now these new ones, they have a few selections you can make. And so those are these key selections. You can choose to include an optional docking clause, and that allows another party to basically accede to the transfer requirements between the controller processor. And there's a lot of uncertainty on how far this can be used, but largely the first thing that comes to mind and where it can clearly be used is intercompany transfers. So you have one company that's an importer, maybe it's the intended importer, but that company may have certain affiliates that it requires to do additional processing on the data. Affiliates of that data importer could accede to the protections in the new standard contractual clauses. It's an optional provision, but one selection you can make. You can also make a selection with regard to specific or general authorization of service providers. This is, again, I mentioned earlier in this presentation that a European concept is specific authorization, different than general authorization, which we have in the US, but you could make that selection, whether you're going to use specific or general authorization. You can also choose the governing law, the venue, and the supervisory authority. Largely, this is going to be driven by where the exporter is located, because it's also likely where the data subjects in the European Union are located, or some proxy. But there is, in a processor context, we very frequently are asked to submit our own preference with regard to the venue, governing law, and supervisory authority. And so those are selections that can be made all within the new standard contractual clauses. In addition, what you will find is that the clauses do clearly state these are standard clauses, and outside of these selections I just told you, you are not allowed to modify these clauses. But what they don't say, and what is very clear, is that you can clarify those minimum requirements. And so these are areas that are commonly clarified. You cannot modify them. You can't amend them. You can clarify them. So a very, generally you see it with regard to instructions, certain disclosure requirements, because you have to provide the data subject disclosure of the standard contractual clauses, but under what circumstances? Under a confidentiality agreement, certain redacted information, outside of the key terms of the standard contractual clauses. You can clarify, you can make certain key clarifications. The one I see all the time that's really helpful to clarify is audit. Yes, you have to submit to an audit, but again, you can clarify who's going to pay for that audit, or you can clarify under what terms you will submit to an audit. After reasonable notice, without business interruption, under a confidentiality agreement. All these things are not modifying the minimum requirement that you have to submit to an audit, but they are clarifications of the process by which you would go through that audit. And in early drafts of the standard contractual clauses, you can see clearly that they're wrestling with these concepts. And so there's no indication that these are not clarifications that you could make, so long as you're not modifying or replacing the terms, the minimum requirements. of these standard contract clauses, you can make these, so far, our guidance is that you can make these business clarifications. Similarly, with indemnification, the general standard in the EU is joint and several liability, but there's cost shifting is certainly was contemplated by European regulators and is a very common practice in anyone who's negotiated a SaaS agreement or any type of agreement. You know, indemnities, cost shifting, and certain caps on liabilities it doesn't eliminate the minimum requirement of joint and several liability. It just clarifies what caps it would be subject to, who would have to do certain cost shifting under an indemnity situation. So between two parties. There's also, I mentioned these amendments, and this is an interesting concept. It's less, to me, it's less interesting in that what the terms of these amendments are, but just that they exist. Because what you're starting to see, here's the tide. A lot of countries are coming out and they're becoming more protectionist is the trend. So sometimes you see that in localization requirements. You see that in Russia. Sometimes you see it in, you can transfer the data, but only under these terms. And so you see that in China, you see that in Europe, like we've been talking about. You can certainly, there's no localization requirement in the EU. You can, it contemplates that you can transfer it under these terms, under the standard contractual clauses with additional provisions. What the amendments are really interesting to me is because they're going to shape your DPA. And I'll tell you, in a few years, this is what your DPA will look like. It will have, because these standard contract clauses are becoming the best practice, the dominant model, basically, is that you might have your service agreement that says, okay, your service agreement requires you to process likely personal data in a certain way. That governs your provision of the services. Then you have a DPA that governs your processing of personal information. Sounds very similar. Then you might also have, you're receiving data from the EU. You might have standard contractual clauses that also talk about the processing of data that you receive from the EU. And there's 3 iterations down. Then you may also have certain addendums that will modify that standard contractual clauses. And that's why you see these DPAs becoming so complex. But I would say 2-3 years time, there's going to be all these addendums that are going to basically say, yeah, you can do it under the standard contractual clauses from the EU, but only with certain addendums. And so that's the direction we're going.
All right. I think this is our last segment of the day, and I'm going to pick up on what Chris is talking about with the transfer of data, cross-border transfer of data using the standard contractual clauses. To facilitate the compliant transfers of data, a business can conduct what we call a transfer impact assessment. The shorthand for that is TIA, to evaluate the risk of a particular transfer and determine what supplementary measures may be required to mitigate unacceptable risk. So Chris talked about the timeline for the development of the transfer mechanism. I'm just going to tie that into where that is in the statutory process. And it really starts with the General Data Protection Regulation, GDPR. Article 46 is the statute that says that transfers out of the European Economic Area are permissible where there is an adequacy decision that's stating that those there's an adequate protection inherent in the process. Those are what we call whitelisted countries. Or there are appropriate safeguards in place with available and enforceable rights for data subjects, and that those rights can be effectively legally exercised by the data subject. And most commonly, these appropriate safeguards for the non-whitelisted countries are achieved through the standard contractual clauses that we've been talking about. So clause 14 of the standard contractual clauses is a clause that explains the transfer impact assessment, and that's where I'm going to focus our conversation. The clause 14 asks you to consider in your analysis. So this assessment is an analysis, as I said, of the risk of the transfer. We want to consider our specific circumstances of the transfer, the laws of the data importer's country, and then the contractual, technical, and organizational safeguards that are in place in order to protect the data that is being transferred. The burden really is on the data importer. I don't know if we've explained data importer and data exporter. Most typically, your data exporter is the controller. So the controller is collecting personal data in their country typically, and then they're sending that to their processor in another country, and their processor becomes the data importer in the country that they're in. But that's not always the case. The data importer really and data exporter is referring to the direction of flow of the information. So the burden of these transfer impact assessments is really on the data importer to know the laws in the country in which they are positioned, to communicate the relevant information back to the data exporter, to monitor for changes in those laws, and then to make adjustments to ensure that there's maintenance of the safeguards that are put into place. So the European Data Protection Board has recommended a 6-step process for implementing these transfer impact assessments. Those steps are know and document your data, determine and verify your transfer to, analyze and assess, identify and adopt any necessary supplementary measures, and then implement any changes based on those supplementary measures that are necessary. And the real important one that often gets forgotten is to always monitor, reassess, learn, and improve. So here's some sample language that will show you how these transfer impact assessments work through these 6 steps. So know your data is the first step. Why, what, and where is the data being processed? What subcontractors are involved? Who are the data subjects? Is there sensitive information included? How often and for how long will the transfers occur? What is the retention period? Those are the things you need to address in that first step. The next step is determine what and verify your transfer to, which is, again, as we've been talking about, is going to be the stranded contractual clauses. The analysis and assessment step is where we're going to identify critical laws in that data importer state and how those critical laws can impact the data that's being transferred. And I'll give just a quick example so you can understand how that works. So in the United States, we have the FISA, the Foreign Intelligence Surveillance Act. It is intended to stop terrorism and for national security measures. But what that law says is that the government can compel disclosure from a business of information, including personal information. They can require the business to give the government that personal information. As Chris stated earlier, that's a concern to foreign countries because they don't necessarily just know or just trust the US government to have the personal data of their residents. And so in order, so that's the law, and that is the risk that the European Union or foreign countries see in having that law and in transferring data to the US because of that law. Well, how do we mitigate that? There's actually a white paper, and the US government has addressed it specifically, that says, hey, we understand what your concerns are. Well, we're really not interested in your commercial sales. That's not what we're trying to do here. We're trying to stop terrorists. And so the mitigation effort is, this is not, your data is not the target of this law. And being able to compare the law to how it's being applied is how is the analysis piece of the transfer impact assessment. If you are transferring data that you think could be subject to FISA in our example, then you might take additional supplementary measures to protect that data. And those measures could, for example, be end-to-end encryption so that the data can't be taken in transit or in storage. And those supplementary measures are what falls into step 4 in the 6-step process, to say that we've made the assessment, we've determined these additional measures need to be put into place. And now step 5 is to actually implement those changes into your security measures. And then again, step 6 is to assess, monitor, and make the changes that are necessary. These next few slides just show some of the supplementary measures that are available. There are administrative measures that kind of deal with your policies and procedures of the business. There are physical measures that deal with how you protect your physical space, your secure areas, your highly sensitive areas. And then there are technical measures, which are obviously super critical in protecting your network and IT systems. And all these measures can be implemented in your business through just on a one-off basis for what you need for your business, or through certification programs that are out there, like the Critical Information System Model or NIST or ISO, many of those programs. So that really takes us to the end of our program, and we appreciate your time, and I'm happy to answer any questions.
Yeah, thank you, Sarah. Great. Well, yes, you made it. We got some questions, so we're going to take those. And I should also, we'll take some questions specific to this presentation, but if people want to stay afterwards, we'll certainly have time also for questions for any of these, any questions on anything that we presented on today after. But yes, please, Melissa.
Yeah, I was just noticing that with some of the carryover between the different states, what are your thoughts on how you list out in your DPA or elsewhere what laws specifically you're compliant to, because the list is getting quite long.
Right. So usually what happens, let's say you're subject to all of these laws, and Melissa's question was, how do we, if there's specific intricacies, how do we call those out for the DPA? And so largely outside of California, what Zahara covered so well is you generally, what we've done in practice is we've defined all of these laws as part of a definition of applicable laws, might be US laws that are applicable. They go into a broader definition of applicable laws. And then we've drafted our obligations as the net obligation. So you don't have to have, 5 different subcontractor authorizations that have specific timing depending on where the requirement's coming from. You might just have one that is the net kind of, lowest common denominator, let's call it, for all of these obligations. And then they all in compliance with applicable laws, and then therefore you would do it in compliance with the specific law that the request is coming under. Yeah. I will say California is our outlier there, and so usually there are some specific call-outs for California. I'll say that. Yeah, Teresa.
What are you seeing?
question refers to sub-processors and the requirement to notify about sub-processing changes. There was a time when, some companies were posting that list online.
Yep. Yeah.
And there were some,
Yep.
European supervisory authorities that planned on that.
Yep.
What is the current
Right.
thinking about that?
Yeah. It's a great question. So what the question was when you're getting sub-processors approved, there's a requirement that you either have specific or general authorization. Could general authorization be interpreted as you just post a list of your sub-processors online, and anytime you make updates to that list, then they're just authorized, they're pre-authorized, and it's really on the controller to go on and check that list diligently and periodically. And sometimes you get companies taking that. There are still a lot of companies taking that stance, that is the interpretation. As you pointed out in your comment, the European Union has opined on this in guidance. And so if you look to this, there's some guidance that came out, I believe it was 2 years ago, on the definitions of processor and sub-processor. And they say in a footnote that you cannot use these hyperlinked lists for the purposes of general authorization. So the European Union says that it's not permitted in guidance. Best practice, you could look right now and type in your Google search bar sub-processor list, and you will be presented with countless companies that are getting authorization through a hyperlinked list.
And that would usually be initially referred to in contract, right?
That's right.
It's your obligation to.
That's right. And then sometimes there's some deviation on whether you have to subscribe to the list or subscribe to updates or how often you check it. So not permitted from guidance from the European Data Protection Board. No opinions so far if that meets the general authorization standard on the US. Lots of large companies are still doing this. Proceed with a little bit of risk. Those are kind of where I stand on it. Yeah. Andrew.
I've seen a lot recently where processes are dictating. Is there any guidance on whether the controller actually is obligated or responsible to do?
Yeah, and sorry, I'm jumping in. This is a really, I like a really interesting question because I've seen a lot of shifting sands. And, oh yeah, let me repeat the question. That's a great point. Basically, whose primary obligation is it to put a DPA in place? Is it the controller's obligation with regard to the processor? Is it the processor's obligation to push it up to the controller? Is that a fair assessment? Like, whose obligation is this to put this thing in place? You have a lot of processors who are putting this in place, and they're just saying, hey, listen, like, go on, you can find Amazon data processing addendum, you'll find it. And they're not going to negotiate it. But from a legal standpoint, whose obligation is this? There's been some shifting sands on this one. And so you kind of start with the GDPR usually, and it seems to be through guidance a primary controller obligation, but the various member states of the EU have come out individually and said it's really a shared responsibility, but maybe a primary controller obligation. We're kind of leaning that way, but there's still obligations on the processor. Interestingly now, if we were to go back up that scoping slide, you can scope into these laws, not just as a controller in these 2023 laws. Some of them do only apply to a business or a controller. Some of them you can individually scope into the obligations as a processor. You could have a certain number of records, and a processor, if we go back and read that, looks like a processor can individually be required to comply with the obligations to put in place a DPA. And so we're really moving in the direction of shared responsibility. Again, we don't have specific guidance in the US on this specific point, which is a really strong one. But where I think we're going is that it's equally shared responsibility. Yeah, great question. Yeah, please in the back.
Yeah, so companies that are building big database and storing information, have you seen any companies take the approach of kind of like a Chinese firewall to separate what the data scientists are doing versus the rest of the organization, so that when they do get a data request, they can say, look, from a business standpoint, this is what we do. The data lake, we've anonymized it,
Yeah.
but obviously they're working with the data and put the full sites together, we can identify it.
Yeah, that's great. Yeah, great question. So the answer is when you have a large set of data, they may put in like a data lake, or even you could just do, I mean, even large databases could be applicable here, and you have different uses for that data. So let's say one element has multiple uses, could be in a data lake. How have you seen companies kind of segment them out, their processing activities for specific data elements that are in that combined set? Yes, and you should. You should have, so like very commonly, you should be able to distinguish your employee data with your customer data. You should be able to distinguish the data that you have a relationship as a processor. Maybe you're just processing it on behalf of certain companies, and your controller, the data you are a controller for. Like you may market to your controller data, but it would be very surprising if you received all this data as a processor, and then you just started using it as a marketing list and you started marketing to it. So you should have certain uses that are specific to certain data elements. That is very common. Now it gets a little harder, and I'm guessing this is maybe where your brain's going, is what if there's all customer data, so I know I'm a processor, but what if it's like I made certain guarantees to this controller and I made certain guarantees to that controller? That's where the California requirement that we talked about, don't combine data. You do have to have specific, obligations with regard to processing for each of those controllers. And so largely that comes into the legal requirement to not combine it in California. And then also it's going to come down to, might come contract by contract with regard to certain controllers. Yeah, sorry, I know that's maybe not satisfying. Does that answer your question? I'm happy to answer your follow-up.
But it's answering from a couple of different things. I'm looking at as a company, if you want to look for a new product, opportunities, etc. If you decouple the identification piece of the data, you just have aggregate data, de-identified data. If you create that firewall, so that they can't ever identify that data, and you can show controls in there that you can't get to, then all of a sudden you're now in a different realm where you can start playing around with that data, looking at different things, because it's no longer falling under about privacy.
Yeah, and I'm sorry, and I missed that part of your question. You're right. It's back almost to a scoping aspect, and there are exceptions. You're right. Under all of these laws, they have, I believe it's all of these laws, de-identified, not anonymized for all these laws, but yes, all these laws have scoping exceptions for de-identified data. There are certain requirements that you show technical measures, and you also make commitments of de-identification, and you can bring the data outside the scope. There's also the limited exception that Malia talked about earlier with regard to encrypting the data. Again, that's a limited exception, not a full exception. But I want to make sure that's very clear that it's just a US standard. De-identification is not a standard of exception for the GDPR. You have to be fully anonymized, meaning a 0% re-identification risk. So yes, but you are right. For outside the scope, if you can't truly de-identify the data outside the scope for these laws, now, can you actually use the data in the way you intended it? Obviously, if you're a marketing data set, it's very hard to market to a specific individual if it's de-identified, or sometimes a lot of the service requires that you have some ability to de-identify. So, sorry, great. Any other questions online that we handle this? We are over time, so I'm gonna. Oh, great, you're answering online. Okay, we're answering some questions online. We'll go direct. We'll also, we're all happy to stay over there doing our happy hour, and so we can also answer questions directly there that you have. So let's stop recording.